Hi, I'm attorney James Doerr, an associate with the criminal law practice group Lavelle Law. One of the primary calls I receive on a regular basis are those involving DUIs. While we hope that you will not find yourself in this circumstance, I would like to offer some basic information about handling a traffic stop if you may be at risk for a DUI. There are several steps in a DUI case involving the traffic stop, the investigation, which can include field sobriety testing, and ultimately the court process. A DUI scenario can begin with a traffic stop for virtually any reason. Having a light out on your car, misuse of a lane, not coming to a complete stop, any standard traffic violation, and of course driving erratically. Once you have been stopped, you enter the most critical phase of the DUI investigation. As soon as the officer approaches your car, they are gathering evidence to be used against you in a court of law. Should they smell alcohol or observe behavior indicating that the driver has been drinking, they will investigate accordingly. It is incumbent that you do not share or offer any other information other than providing your driver's license, your registration, and insurance card as requested by the officer. The officer is likely to ask you to submit to one or more field sobriety tests. You do not have to submit to field sobriety testing. These tests are designed to specifically allow the police to gather evidence that you've been driving under the influence of alcohol. In conducting his investigation, the arresting officer will use 3 standardized field sobriety tests. Those tests are as follows. First is a horizontal gaze nystagmus test. This is a test where the officer is looking for involuntary shaking or jerking of the eyes. The second test is a walk and turn test. This will be asked to take 9 steps in a heel-to-toe fashion while maintaining your balance along a straight line. The third test, standardized test, is a one-leg stand test. You'll be asked to perform standing on one leg for 30 seconds without putting your foot down or without swaying from side to side. There are several reasons not to submit to field sobriety testing, including the possibility that you have a physical condition of some sort that would prevent you from passing the test, even if unimpaired. Perhaps the nerves of being stopped and tested could cause negative results, which could be used unfairly against you in a court of law. Keep in mind, however, that even if the truth is that you are impaired, you do not have to submit to field sobriety testing. It's very possible the arresting officer will ask you to submit to chemical testing. These tests would include blowing into a breathalyzer, which is designed to measure the level of alcohol in your blood. Because these tests produce strong evidence that can be used against you in a court of law, and because of possibility of erroneous results, we recommend that you respectfully refuse to submit to all chemical tests. While it is in your right to refuse these tests, there will be consequences. Namely, you will be taken to jail. However, it is far easier for a good criminal defense attorney to challenge these serious charges when the evidence against you has been limited and managed. At Lavelle Law, we strongly urge you to never operate a motor vehicle after you've been consuming alcohol or drugs of any type. Please use a designated driver, call a cab, or stay where you are to avoid a DUI charge. If you would like to speak with me about your DUI case, I can be reached at 847-705-7555. I'd be happy to talk to you about the details of your case. I will work diligently to protect your rights from that very first call.
To learn more about your rights in DUI cases and to schedule a free consultation, call Lavelle Law at 847-705-7555 or visit us at lavellelaw.com. We encourage you to always drink responsibly and never drive while impaired. But should you need exceptional legal service, call Lavelle Law at 847-705-7555.